Any mention?
But, I'd like to make a mention of item 16 of the hearing list.
Upgrading?
Yes, Madam.
16?
I'm waiting for a week's time. Yes, Madam, the matter was heard. And my lord, there was some this is with regard to that increment. I received some instructions. I stated my object, Madam. I received some
instructions you received was whether for the college pay, whether there was any assistance from UGC at all.
No, my lord, I received the instructions. But my lord, my difficulty is that if I don't see to the officers, my lord, I will not have clarity, my lord. Because whatever I want to submit before the submit, my lord,
Okay.
My lord, only thing, Lordship, my lord, my objection is this over the last 4 months, my lord, matter has been heard, my lord. These things cannot go on like this, my lord. Only thing Lordship has for 80% and 20%.
My lord, this is
Shouldn't
not
happen like this, my lord.
One week, yes.
On the next date, I want to have.
Yes. Where? Why? $2020 matter. What do you have to do with it? What do you want to do with the matter?
Adjourn the matter, Your Lordship.
When some people are there. 1 week, okay.
2 weeks, Your Lordship.
Is it going to be Basu here?
No, Your Lordship. No. This is a contempt matter regarding the 2 weeks, Your Lordship.
Why?
We need some time to Your Lordship to prepare.
1 week, pick it up. Yes.
Highly
After 1 week.
Your Lordship, I beg to mention item number 25. This is pertaining to its compassionate ground. So now the documents that we need to bring before Your Lordship, now we have to search from. Now we went to district council, and district council till now we haven't get the documents. So we need some more time to.
This is against the council or in the state?
No, this is against the state, but there are documents in the district council, so we need to get from the district council.
Okay, this other thing. Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 26 and 27. Since the petitioner expired on 29 August, we are still waiting for the death certificate to take necessary steps for filing substitution.
Is the take of action still survive?
Yes, Your Lordship.
The legal heirs are there?
Yes.
Whose phone is that?
Three weeks, Your Lordship.
Hello, Blecho.
See, I beg to mention item number 17. Here, Lordship, I need some clarification from my client, Lordship, because the previous occasion when the matter was heard, my learned senior has raised that I have entered appearance in way back in 2009 before the trial court, Lordship. So, with regard to that, I just want to the petitioner, Lordship. Because I said that, Lordship, in 2017, when the matter was transferred from Tura to Ampati, then I have entered appearance. But in one order, it has been reflected that respondent number 1 and 4. 1 is government and 4 is private, represented by so-and-so. And only after that, nowhere mentioned, Lordship. So with that...
Lordship, this is a matter Lordship will recall. Suit was filed in 2009 in Garo Hills, and a written statement was sought to be filed in 2018 or around that time. And they've claimed that they received notice only around 2017. But we've indicated from the records, that the order sheet records, that they had appeared in 2007 itself.
Only one word, that would regard to
called for the lower court records as well.
How would you verify that?
No, Lordship, here government as well as the private. Because
how will you verify that you appear, you didn't appear?
No, I'll just because I have to contact through that lawyer from that Ampati, Lordship, because I have a contact with him, so he will get the clarification from her. Because
will they remember whether they appeared or not in one date in 2009? You ask any lawyer here.
And the lawyers have
who's
changed.
been practicing since 2005.
That's the yes,
Will they
Lordship.
remember?
And the councils had changed over this entire period. Moreover, Lordships had called for the lower court records, those have arrived.
Next week. Well, we won't keep it pending for nothing.
If he has any difficulty next week, Lordship, we can make an endeavor.
Then in the meantime, I can have the clarification also, Lordship.
No, received since July, the records. Mr. Sheikh was not available, that's why. Anyway, Mr. S.A. Sheikh prays for allowed 2 weeks' time to obtain necessary instructions in the matter from his clients. Yes, less up to 2 weeks. 2 weeks you wanted, correct?
Hello.
Please, Your Lordship. Lordship, I beg to mention item number 19.
19?
19, Your Lordship. No objection, Your Lordship. Lordship, 1 week's time, Your Lordship. Will be granted.
Last order, we said no adjournment is taken today, I suppose. Check order sheet.
No, Your Lordship.
What does it say? Last order.
No, Your Lordship.
Does not say like that.
No, Your Lordship. Last order is on 19, sir.
Last order is when?
1909, Lordship.
99, okay. On the request of counsel for the parties, this matter to 2 weeks. We will... Yes.
Earlier. May please, Your Lordship. Lordship, I beg to make a mention of item number 24. I pay for some time, Lordship, because counsel is indisposed.
Who's counsel?
Ikhalanam.
Where's the petitioner? You informed him? No objection, Mr. Siddiqui?
When he's indisposed, what can I say?
2 weeks, okay, yes, 24.
I beg to mention item number 23.
23.
May this matter be taken up after 2 weeks, Your Lordship.
You have objections?
No, Your Lordship.
No. When will the day come when you have objections to adjournment? 2 weeks. On the paper, yes.
Supplementary list, item number 1.
Lordship, may I kindly pass it over for some time, Lordship? Highly obliged, Lordship.
Item number 2.
My Lord, here, in this case, the petitioner had joined his service in the year 1985 under the respondent number 5 and thereafter retired in the year 2009.
Joined in 95?
1985.
85.
Retired in 2009. My Lord, all my pensionary benefits have been released to me, disbursed to me. But however, my increments right from 1985 has not been released.
How come?
In a surprising manner, there is no order to that effect. So being aggrieved, I am before your Lordship. At this juncture, I am praying for notice.
Who's appearing for the state?
And for the state, Your Lordship, 1, 2, 6, 8 and 9, Your Lordship.
Heard Mr. Arguro issue notice. MSI Bengal present on items 1, 2, 6, 8 and 9. No further to follow for Mr. K.
Number 7, Your Lordship.
Present on number 7. The notice complete list after 3 weeks for instructions of affidavit.
Deployed.
Obliged, Lordship.
Item number 3.
Yes, Mr. Nat.
May I please, Your Lordship? Actually, this is in regard to, yes, my Lord, implementation of the PF schemes, my Lord.
Of the?
Employees Provident Fund schemes. That has not been under the Act of 1952. That has not been...
No, I mean, like, where they employed?
They are employing in PWD, Public Works Department, my Lord, in River District. And They have been employed casually and contractually also.
Your filings on behalf of whom?
On behalf of the, I am the president of the trade union.
Where's the registration certificate?
Yes, in the
Registered under Trade Unions Act.
Annexure 11, my lord. My lord.
Under Trade Unions Act.
Yes.
Now, where's the authorization that you come on their behalf? Where's the meeting? The resolution
my lord,
empowering you to.
That is the constitution, my lord. I have my lord constitution. I have not.
Where's the constitution?
I have not annexed my lord.
Because you're filing the representative capacity.
In the constitution.
Where are you? You're saying you're the president. Where is it shown that you're a president? In the petition.
In the petition is first paragraph, my lord.
In the first?
Second paragraph, my lord.
No, I mean the document.
My lord.
This is the list of office bearers of this whatever trade union.
That one is, I think.
It's not been enclosed, you're not sure.
Not have been.
Then how are you maintaining this petition, Mr. Nath? Anybody can say that I'm the. You can get trade union certificate from somewhere.
There's a constitution resolution is also there.
You make your return complete. No, where's the list of office bearers? Why you have not annexed it?
My lord, this is, I think I've missed this one. My lord, I'll file additional. This is the, in the constitution, my name is there.
The constitution is not here, Mr. Nath. The court can't look at papers, look at a signboard and say yes, like, you know.
And take allowed to file additional.
Mr. HR Nath, the council please be allowed to file an additional affidavit. Bring on record the office bearers of the petitioner trade union just after 1 week. I will withdraw it and file it afresh. If you want to insert other documents, it's up to you.
I'll file additional, my lord.
Item number 4.
This is petitioner is a legal wife of the deceased employee. Deceased employee is a permanent employee working as a farm operator. Yes, service has been regularized. But while he was in service, he expired, your lordship. But now the wife is coming only for the payment of the pension and other service benefit of the deceased employee. Because he has been regularized and he is eligible for the payment of pension also.
When did he die?
Died in the 20 August 2012, lordship. Died in hardness.
He never got any.
No,
from then till now.
Lordship.
So what are you doing all this while for 11 years?
Just doing some labor work.
No, what are you doing? You're not aware of your rights.
Because the wife is actually not aware because he's illiterate. That's why. Maybe.
No, not that. I mean, he retired in 2012 as what?
Yes.
Oh, he died. Sorry.
Died
in harness. 2012.
August 2012.
What is the name of the deceased employee?
Name of the deceased employee, lordship, is Moniram S. Sangma.
Moniram S. Sangma.
Lordship.
So how can this happen? This is Moniram Sangma has been, as per this chart at page 21, item number 13, correct?
Yes, this page 21, 17.
Item
yes.
Is at number 14, correct?
Lordship.
Or 13, sorry.
13. Moniram. 13.
Where's the claim you made before the authorities?
Lordship.
You filed representation before them?
Of course,
Did you approach
she just went verbally.
No, not verbally.
No, no.
Don't give a submission.
Lordship, no, she didn't file any representation.
Then how you come here? Then how do you know? You don't. Are you? Maybe someone else is enjoying a family pension.
No, Lordship. She is the only sole wife. This she legally wife. This marriage certificate also.
No, I'm not saying legal or legal wife, but
Lordship,
11 years if the person has died and if their work charge regularized, they're entitled to pensionary benefits.
Lordship.
How is it possible that the authorities won't call you?
Let the state recipient and let him get instruction, Lordship. If anything.
No, why should get instruction? You should be aware of your case also.
No, actually, as per the instruction by the petitioner, she said there is no any other wife.
Not any other wife. Has she got any amounts or not?
No, she said they have not received anything.
Very strange case, Mr. Guru.
My lord, definitely if the petitioner's name is in the service record, the authority will definitely call them, notify them. But surprisingly, that has not happened, and then he has come after 11 years. And then there is no approach from his side.
Not even one letter to the department to find out why not being paid family pension.
Yes, it's not filed.
So when the client came to you, you said file a writ.
Lordship, let the
don't dictate the orders that you pass as kind of order. So when the client came, you said, "Should we come file a writ?" Is that your advice?
How is he aggrieved? He has never made an attempt.
Exactly. When you knock on the doors of the court,
of course,
the court is the last resort, correct?
Yes, it is a remedy, of course. I will not say because it's not mandatory also on the part of the petitioner.
It's just that you want a quick fix solution.
He has got some kind of legal expectation because they are not denying the fact because disease.
Where is not denied?
No, I'm not saying they are not. They are also not denying my regularization.
Then since the pension matter, you should know. Otherwise,
Lordship,
you can't just come and hold the response to court without taking any steps on your own first. You're aware of that.
Lordship, that is their Lordship, but however, it does not bar from approaching Lordship.
There's no bar. But what is the way? When did we say there's a bar? Yeah. You know what is this called? You write in your own course title, Civil Extraordinary Writ Jurisdiction. What is extraordinary jurisdiction? It's for extraordinary circumstances. Under 226. You're a seasoned lawyer, you should know that. Just filing a case, sake of filing a case should not be done. Yes, heard Mr. P.D. Sangma. You should notice.
I'm accepting notice on behalf of.
Our Guru accept notice on behalf of 1124, Mr. Kikama.
For 5, your Lordship.
For 5, yes. Just after 4 weeks for instruction. You find out what happened.
Thank you. Lordship.
Main list item number 1.
Well, the affidavit has been filed.
What do you say in the affidavit?
Just the delay has been condoned, my lord. It is not that the entire case was allowed.
How many? Where's the affidavit? 1 and 29.
29, yes, sir. If my lord may kindly see page 5.
Yes.
Page 5. There are D and E.
You got the affidavit, Mr. Sama?
recently I have not gone through the PDP.
Will dispose it off now?
Lordship, my submission is this, Lordship. The conduct of the petitioner, the private respondent. Because it is after they are coming after 9 years, Lordship. They have not been complying with the court earlier previous court order. This is not the first time, and they have taken the matter in the light manner.
Your challenge was that there was no condition application filed
Lordship,
as per the direction of this court, and that the matter has been admitted for rehearing, and the delay has been condoned. Correct. But as per the affidavit, it says that the rehearing has not been done of the appeal.
Yes.
Lordship.
And number two, that only that they have condoned the delay.
Yes.
The condoning the delay, they in the first they have admitted the fact that they have not filed a separate application as per the direction of the.
But it's not a statutory.
While condoning the Lordship, while condoning the delay, they have to specify the each and every date the how many. This is after 9 years, Lordship. There should be some sufficient ground has to be mentioned. The purpose of the Limitation Act is just they cannot take it.
Limitation Act is not applicable here. It's only that it's before CM and it's like fundamental principle of judicial procedure. Correct. There been justice, equity, and good conscience. Correct. So now, if someone shows good cause, that delay was due to certain factors. If the authority is satisfied that yes, its discretionary powers exercised, okay, to condone a delay. It's not under Limitation Act. It is not incumbent upon. You have a right to make objection. Have you made objection to the conditional application before the CM?
No.
You made objection.
Lordship, that I not mistake. They have filed the objection also to that.
No, did you file objection or not
Lordship,
when the matter was heard before the CM?
We have filed the objection.
Then after that, both parties were heard.
Both parties were, but our objection was not recorded properly by the court.
Now, he will dictate everything to the court.
No, actually, that
Your Lordship
whatever the submission has to be recorded because there is an objection. Strong objection has been filed because after 9 years they are coming to the
page
court.
35 of the writ petition, where the order of this honourable court was enclosed, and the order says the chief executive member in his discretion shall examine the same on its merit and pass order thereon. It is made clear that the impugn order herein shall not be disturbed. That is his appointment. His appointment is not been disturbed till now. Now the entire case has to be decided, my lord, and we are deciding as per the order of this honourable court.
See, Mr. Sangma, I understand your apprehension. You say once it's this condoned, the matter is reheard, you'll be thrown out. That is the apprehension, correct?
So, that is not the present because my only contention is that they happened frequently neglecting to appear before the even before the EM and CM also. Let me just may I take you to the annexure page 26 of my petition.
Let me see the impugn order first.
Impugn order is on page 46.
46 more.
The relevant part is page 47. There are 7, 8.
They have admitted, Lordship. They have not mentioned how many days. 7 very clearly they have mentioned. They said that even other word like condonation or record.
Only number 8. I think needs some interference. Let them rehear the condemnation matter for a proper application. You want to do it today?
After some time, Lordship.
After some time.
No, after 1 week. I'll go through all this.
We'll dispose it off. It's going in your favor. But you want to wait? Then no, madam. Yes, after it's been filed on behalf of the respondents 1, 2, 3, the writ petitions admitted for. Not necessarily. This is matter for 1 week. Let's dispose of next day.
Lordship.
Item number 2.
My lord, we were required to take certain instructions, my lord. I'm praying for a date on Thursday, my lord. I'm yet to receive the instruction.
What instructions?
Well, in view of the affidavit filed by the private respondent.
What do you see in the affidavit? What do you see in the affidavit today?
These are two different land.
So, no, that is why, my lord, I need to have instructions.
Since the 14th, you're taking time.
No, my lord, only the last occasion we had taken. Now we're trying to make contacts with him. Trying to make contacts with him, my lord. We have not been able to. My lord. They are from remote area of Garo Hills.
So then we'll dismiss the review?
I've in fact communicated it through some
Mr. Thapa prays for allowed further 1 week's time to obtain instructions.
Item number 3.
In item number 3, my lord, we are supposed to take, my lord, instructions with regards to the notice, my lord. My lord, I'm praying, my lord, if I may be allowed to take fresh steps, my lord, in respect
on whom on?
Respondent number 3
to 6, 11 and 12.
Yes, lordship. Because it was taken earlier, my lord, and after the matter was remanded back, my lord, no steps were taken, my lord.
What about Mr. Jindal? You file here?
They filed, my lord.
They filed. Status filed.
I have filed, yes, sir.
Okay, Mr. K. S. Chandra, counsel petitioner, submits that prays that he may be allowed to take fresh steps on the respondents numbers 3 to 6, 11 and 12, as after the matter has been remanded, no fresh notice has been issued to them. According prayers allowed, petitioners allowed 1 week's time to take necessary steps on the said respondents.
Item number 4.
I'm appearing for respondent
4 to 8.
my lord. We are yet to, my lord, file affidavit, my lord. I'm seeking 2 weeks time, my lord. Affidavit is ready, my lord. Otherwise, my lord, we have sent it for vetting to the court.
What about your pain for whom?
Respondent name. We are yet to file our affidavit.
Your name?
I Kharmuzai. I Kharmuzai.
No. From how? 11?
I'm appearing for respondent number 11, my lord.
Not filing?
Not filing any affidavit.
1, 2, 3. Mr. S. Chanda, the counsel for response 4 to 8. Please have further 2 weeks' time to file affidavit stop. You're not filing? Already filed.
We are yet to file.
Similar prayers made by so and so on behalf of respondent number 9. The other respondents, respondent number 10 and 11, submit that no affidavit be forthcoming from their side. That's up to 2 weeks, yes. For affidavits by respondents
4 to 8 and
9. 4 to 8
and 9.
And 9 yeah.
Item number 5.
Please, Your Lordship, I'm praying for further 3 weeks' time to file our rejoinder, Your Lordship.
How many times you've taken?
This is the second time, Your Lordship.
Appearing for respondent number 4, Your Lordship.
Last time 3, you appeared for 3 or 4?
4, Your Lordship.
Sure?
Yes, Your Lordship.
As per the order sheet, you appeared for 3 and RG Sandram for 4.
No, for 4, Your Lordship.
Who's appearing for 3?
Sindram.
Chief, it's Sindram, Your Lordship.
One Mr. Sindram.
Sandram for 3?
Yes, Your Lordship.
Was wrongly shown here.
Yes, Your Lordship. Sindram appearing for same of Maria, I'm appearing for 4, Your Lordship.
Okay, Mr. P. first one before praise for allowed. For 2 weeks' time for affidavit.
I filed, Your Lordship.
Oh, you already filed. Or rejoined, sorry.
Rejoined.
Mr. S. Dingdor.
on behalf of the petitioner prays for allowed for the 2 weeks time for the joint affidavits filed by respondents 3 and 4. 3 and 4.
Item number 6.
Lordship, I have received the affidavit filed by respondent number 6 today, Lordship. I'll need some time to.
Also, there was some delay on our part. We filed it today. It may not have reached Lordship's file. We've served them a copy as well.
You want joinder?
I will file it.
Mr. Pandey prays for allowed 2 weeks time for the joint affidavit filed by the respondent number
6.
6.
I will file, Lordship.
7.
I will be filing rejoinder against the state also, Lordship. They have already filed in the last
Notify joint affidavits to the affidavit by respondents.
Lordship, I'm praying for 3 weeks' time for rejoinder. Annexures are actually missing. We have only received yesterday. I'm praying for 3 weeks. It will be fine.
3 weeks for rejoinder? No.
No, only yesterday I received the annexures to the affidavit filed by the state. Inadvertently, even we did not notice, and they.
Why 3 weeks?
I had served a copy on them. Apparently,
Without
they
the annexures.
mislaid it.
Okay. As prayed, 2 weeks time granted to Mr. So for a petitioner file the joinder.
8.
Yes.
Lordship, I pray for 2 weeks' time for rejoinder affidavit.
So also prays for and allowed 2 weeks time for rejoinder affidavit by respondent number 1 to 4.
Your Lordship.
You already filed yourself. 1 to 4 and 5. Yes.
9.
May I please, Your Lordship? We were supposed to file a rejoinder. We need more time, Lordship.
1 to 6. What's your name?
And Sangma, Your Lordship.
Sangma. Prays for and allowed for the 2 weeks time for the joinder list after. And so.
10.
Lordship, the respondents are yet to file the affidavit.
For 1, 2, 3, and 4, my lord, I'm praying for further 2 weeks' time.
Your Lordship, 4, 5, 6, and 7, we have filed the affidavit.
You haven't filed, Mr. Day.
I'm praying for 2 weeks' time, Lordship. We have received.
Mr. Day prays that will out further
2
weeks time file affidavit stop. Mr. Missil on behalf 5 to 7 submits that affidavit on behalf said response already been filed. Yes, just after 2 weeks affidavit by respondent.
1 to 4.
1 to 4.
11.
Lordship, they are supposed to file one affidavit bringing on record.
5.
My lord, yes, my lord. My lord, the affidavit is ready, my lord. The only difficulty is the respondent number 5 is in Delhi, my lord, posted in Delhi. So he's traveling back, my lord. So
what about 3 and 4?
1 week's time.
Your Lordship, we have already issued a notice to the respondent 5. We won't be filing our affidavit, Your Lordship.
3 and 4. You already filed it. You already filed it. Have you filed affidavit 3 and 4? What are you submitting? I don't understand.
Lordship, we have just issued notice to the private respondent.
What do you mean issued notice?
For the removal of the residence staff, Your Lordship. Shillong is full for Your Lordship.
Oh, you mean you're not filed affidavit one?
Won't be filing our
The difficulty is, my lord, affidavit is ready otherwise, my lord. Only difficulty is, my lord, he's posted in Delhi and he's traveling, my lord. So 1 week's time, my lord. The meantime, we'll
1 and 2 already filed.
Yes, required.
Yes, Ms. S. Chanda submits that praise that he allowed just 1 week further time to file affidavit for R5. Praise allowed. The other respondents submit that no affidavit forthcoming from their end, from their side. Yes.
Hi, Liam.
12.
Your Lordship, we've just received instructions. I'm praying for 3 weeks' time, Your Lordship, to file the affidavit.
1 to 4.
Yes, Your Lordship.
And 7.
And 7, Your Lordship. However, 7 has already filed, Your Lordship. So I'll be filing on behalf of 124.
For respondent 5, Lordship. You've already filed the affidavit.
Mr. MS, that in your country pays funds allowed further 2 weeks' time to file on behalf of respondents 1 to 4. This after 2 weeks.
Obliged, Your Lordship.
13.
Lordship, we've sent the affidavit for signatures. I'm praying for a week's time. In the meantime, we're also trying to resolve the
What's the matter about?
Non-payment of completion the work for contract. There's completion certificate. Even money is sanctioned, Lordship. The page 17. They have even sanctioned the money.
For the 2 weeks' time granted as prayed for affidavit list after 2 weeks. Yes.
14.
This matter may be disposed of it.
Yes.
I filed my affidavit and then matter may be disposed of. Matter may be disposed of.
In which way?
Because
what's the matter about?
Matter about this, there was the overload working. So due to this, it was barred to participate in the tender.
Yes.
So subsequent review, this comes as petitioner is in position to take the workload.
You've got the affidavit, Mr. Nongpur. Infructuous now.
Tender already has been allotted.
There is only one issue in the affidavit. They say that in case if there's a single contract, then they'll issue show cause notice. But in my case, they say that it's a multiple contracts, so they are not required to issue show cause notice. Now that is misplaced, highly misplaced, Your Lordship. As per the service manual which is provided, Lordship, the service manual clearly provides that they have to issue me a show cause notice before any adverse remark is issued.
Catch your breath first.
Lordship.
Yes. So in this case, his tender also had been accepted, and I've given in.
Where the affidavit? Let's see.
And it's a one you receive page 11.
Annexure 1. Yes. Annexure A or Annexure 1? Annexure A.
This will have no bearing in these are subsequent contracts which I have participated. Because there's an interim order passed by this court.
What's WLR?
Walk road return, Lordship.
Okay.
And it is not perpetual, Your Lordship. It is not. It will be reviewed in every 3 months. And in his case, it is already.
Well, it makes sense also. How can you issue show cause for multiple contracts? Show cause issues single contract. But the assessment of the work done on a single contract. You can't make an overall assessment and show cause you.
No, Lordship. The manual does not say single contracts, Lordship.
Does not say, but even then, that's common sense.
Lordship, may kindly come to page 23 of the repetition. Of the repetition. That is the manual which I have been relying upon.
Let's see a prayer first. 1 second.
Clause 8, Your Lordship, at the bottom. Seven, Lordship.
Now, which page you're referring to?
Page 23.
Yes.
These are the guidelines, Your Lordship. Your Lordship, at the bottom, at clause 7, show cause notice for proposed adverse remarks in workload return shall be served by the accepting officer of contracts latest by 10th of the last month of the quarter. Copy of
But
the
this,
same
but show cause is not for the shoddy work. It's only that he overloaded.
No,
That's
Lordship,
all.
what happened is every quarterly the MES, they'll have to ascertain my contract, the work which has been awarded to me. Now, if there's any adverse remark to be issued in my favor, then they'll have to first show cause why that adverse remark should not be given.
Yes.
So that is the law, Your Lordship. Now, without following this, Lordship, they have simply.
Where's the impugn order where you've given adverse
Now,
remark
the
against you?
impugn WLR is, Lordship, at page 54, Lordship. Page 54, annexure 4.
Where you mentioned?
Lordship.
Where is your name mentioned?
My name is at serial number. Lordship, serial at page 55D at serial number 140.
D?
55D at page 55D, serial number 140.
Where are you mentioned your firm?
This 140.
140, serial number 140.
55D.
55D.
Page
number
55?
D, Lordship, yes. This is a type copy.
Oh,
of D.
okay, right. 54. On this chart, you mean? Yes.
Lordship. At serial number 140 is the
Slow
petition.
progress, okay. Yes, then?
Lordship, next, before slow progress, there's a remark here, no.
No means?
No means that is the adverse remark.
Whether capable of handling more load.
Now that is the adverse remark which has been issued in my favor.
Okay. Right. And the others impugn order?
Now the other letter, Lordship, is at page 60. Page 60. As soon as I came to learn about the impugned WLR, then I've written a representation. Against that representation, they have rejected at page 60, Lordship.
So what is the reply to this, in the affidavit? What did they say?
They have said nothing, Your Lordship. It's silent on all that aspect, Your Lordship.
What is about the?
Para 5, Your Lordship. Para 5 of the
affidavit.
That as regards statement made in para 3 of the answering respondent states that petitioner is trying to mislead his honorable court and states that the remark of the authority as regard to the performance of the petitioner was reflected in the said report on considering the contract work executed by the contractor having poor performance. Hence, no show cause notice was issued against Uttam Saha.
Then after this it is pertinent to mention here that and subsequently it is pertinent to mention here that the show cause notice is issued in the event of delay by the contract in executing the single contract. It is further mentioned that the contractor may be work under the various division and the competent authority decide the WLR remarks after taking into account the overall progress of all contract under the.
No, but only the very simple question is before issuing these remarks whether he was show cause or not. He wasn't.
Yes. So, Your Lordship, now we have taken that next review we have given here in our affidavit. The next review it has been says yes, and
where's the next review?
Next review order, Your Lordship, it is going to be passed by the competent.
When?
It will be very soon. It will publish that.
Tonight it will be passed.
So it will pass. So our conference considering and after
pass contractor.
Yes.
Yes.
And then here you will receive the whatever tender he has submitted. So there is no bar at the moment. It is the contract.
Take down.
Lordship, I have one judgment which by the Delhi High Court on similar footing has passed. Had set aside the impugned WLR.
No, it's simple. Nothing here. Yes. The petitioner.
Your Lordship, at the moment, whatsoever the WLR has issued earlier, there's no relevancy because.
No, okay. Has
a very short order. The affidavit has been filed by the respondents today, wherein it has been indicated that the earlier remarks in WLR's workload ratio
report
return
return workload return bracket WLR has no longer any significance, and that in fact by order dated 16 September 2023 the writ petitioner has been awarded a fresh contract amounting to rupees 4 crore 62 lakh 81,900 only. 960 only. Stop. Stop. Ms. Abdebnath submits that the very fact that a fresh contract has been awarded to the writ petitioner is testimony to the fact that the purported alleged adverse entries, adverse remarks, as given affidavit, are not taken into consideration any longer and have no significance. Stop. He therefore prays that the matter has since been infructuous, as reviews for the pending contracts, as fresh reviews pending contracts are due to be assessed and reports released. Stop. Next paragraph. Mr. M.L. Nongpure Land Council petitioner, however, has submitted that the very reason for the writ petitioner approaching this court was that in the issuance of the adverse remarks of WLR Simon for quarter ending March 2023, no show cause notice was issued as mandated by, where the page?
Page 23, page 22 is the...
As mandated by, what is that called?
Next at 2.
As mandated by the
Manual of Contract.
By the Military Engineering Services Manual on Contracts 2020 at clause 32.2. How do you write it?
Roman 7.
33.2, Lordship.
32.2. Then this is
quarterly workload return WR Annexure P2 Part 1 and 2 and surplus 8.
Approach this court. What?
Quarter ending March 2023, you should cause notice was issued as mandated by the Military Engineering Service Manual on Contract
2020 or 2022? The bracket 30.2 I7 Roman 7 small 7
Your Lordship,
I
before
bracket
that, Your Lordship.
Yes, quarterly workload returns. It's corrected. He'll make a mess of it. Before that, at clause 32.2, anta bracket, quarterly workload returns, bracket WLR, close bracket, annexure P-2, comma, part 1 and 2. Court has a good mind, I mean, to stop these mobile phones inside the court, because number one, forget the noise, is that it is noticed that the junior counsel, instead of observing court proceedings or listening to the court, all of them are bent over the phone, like playing with the phones. You can see it from here. All of them, it's 95% are just playing the phone. All the lawyers. It's not a it's not a phenomena that happens here. It happens everywhere. You go to airports, you go in any public place, like people are just playing the phones. So maybe if juniors are more attentive to the court proceedings and what the seniors are, even when their own senior is submitting, the junior bench playing the phone, you can see it all the time.
This is so worth it. When, as per my knowledge, sometimes I used to say this, don't do this one.
You also watch yourself.
Yeah, as a senior, yeah. Then I tell something else. That's
I know it's necessary to call your senior and all over the phone, but then like at least you should have some, for you're in the profession, you have, it's you owe that to yourself, not to be too addicted to these devices. It's inside the court, all of them. You see all of them, all on the phone. Anyway, sorry, no? Okay, so he therefore submits that, notwithstanding the fact that the quarter or the report for the quarter has since elapsed, the adverse entries having a detrimental effect upon his track record should be expunged. Stump. Next paragraph. I have heard the counsel with the parties, and especially submissions made by Mr. R. Devnath, that the WLR reports that were made for the quarter ending 2023 are no longer of any significance, inasmuch as fresh tender has also been allotted to the petitioner. That shows that his performance is up to the mark. As submitted, this court also examined the manual on contract 2022-2020, where set close of quote, where 33.27, it has been provided as follows. It has been provided as follows. So, 7. Okay, I'll flag it for you. Seven and 8. Okay. Let's go to examine the it has been stipulated as follows. And after that, a perusal of the above provisions clearly indicate that before any report is generated, especially if the same adverse show cause should have been issued to the petitioner, which admittedly was not adhered to the present case. However, as a matter
As this episode has, however, lost its significance in view of the fresh contract, this matter stands disposed of, however. This matter stands disposed of. Atau however arsin, however boleh tu, however starts with however boleh. Boleh. Before that. Especially what? Especially what? Especially adverse. Especially adverse remarks. To enable him to reply to the same. Stop. So I'm saying before any final, before I reply to the same. Stop. In the present case, however, as this episode is no longer relevant or significant in view of the issuance of fresh tender, this matter stands disposed of, however. The remarks made by the impugned letter dated 11/8, dated the
WLR impugn is 27 July 2020.
Lecture 4. The WLR return dated 27 July 2023 as far as concerns the petitioner, as also next letter is
Annexure 6, page 60.
as also letter dated 11 August 2023 shall stand expunged from the records. So matter upon stands disposed of. Yes.
Congratulations.
You take your judgment back.
Item 15.
May it please your Lordship. Lordship, I'm praying for further 2 weeks' time to file an affidavit in this matter.
It's in the hearing list?
No, my
Lord. Oh, sorry. No objection.
Third consecutive time.
What's the matter about?
Lordship, for refund of stamp duty that we have paid, my lord.
Okay, Mr. So, hand praise for the 2 weeks time for the affidavit. Yes.
Second call, supplementary list item number 1.
My lord, the treated petitioners agree with the order passed by the village authorities prohibiting or excommunicating them from not holding any post of secretary, headman, or any members.
Just come again. Sorry, I didn't.
They
agree with what?
They are aggrieved by the order prohibiting them not to involve or not to hold any leadership post in the village as a secretary, headman, or any members in the committee in the village. So I agree with this. There was a formation of new localities from the Maunai village, carving out and form a new village. And my clan, Lingdo clan, has the larger portion of this newly carved out area is owned by these particular clans. So there was no consultation, there was no meeting called by the headman. They proposed for the creation. So these people, along with the petitioners and other entire clan members, opposed that one and tried the protest complaint before the CMship for intervention. CMship, instead of intervening, he directed both the parties to settle among themselves. Thereafter, my lord, the other side went to district council, and the creation is correct or not, it is pending in district council. Now, to prevent the petitioner to pursue further, they passed an order prohibiting these 3 gentlemen not to hold any public post.
Now, one thing, Mr. Chare, so you mean to say you're against or for the creation of the village?
We are against the creation.
You're against, okay.
Against the
creation. You say that this is a certain place where the clan owns all the land.
A clan almost owns the land.
What clan is this?
Yes, it is a Lingdo Maunai. And there are 45 stones are there, monoliths are there.
So, okay,
Lingdo Monai, they control that area, correct?
Yes.
So then you and these who are the persons trying to create a new village?
Now the village headman, the Maunai village, my parents' headman wants to create a new village.
You are opposed to it?
We are opposed to that.
Along with the clan?
Along with the clan members, entire clan members. So entire clan members put up a protest before this chief also. That is still pending. Now
But now, you mean to say the clan members because they were not aware of it, or?
No, we are aware of the creation. So the village headmen say that we created new village, so-called Kesanai Maunai, new village, and asked the chief to issue a sanad. So after coming to know this clan member, Lingdo clan, put a protest
along with
these three petitioners. Now, chief did not intervene. Chief rather directed all of them to go and speak to the village headman and resolve among ourselves.
So what's the situation? The village has been created?
Village is in the process. Sanad not yet issued.
So now, why you agree that not allowing you to hold any office?
Yes.
On what reason?
Now
by the same?
Because by the headman, saying that I oppose that creation. Lordship, can you see? There are only two letters. Lordship, can you see? First, he prohibits all the members. Page number 40.
Page number?
40, my lord.
I was trying to understand the matter. Yes. Page number 40. 40,
my lord. This is issued by respondent village. May I take as point, the last point, resolve that to disallow the members of the Lingdo Maunai clan to participate in the administration of the Maunai village and also in any other matters. So they prohibited entire members of the clan.
Of the clan, and you belong to Lingdo Maunai clan also?
Yes, I included that.
Title is Lingdo Maunai, okay.
Yes, included that.
So until you withdraw your opposition to creation of the village?
Yes. And later on, my lord, this was placed.
But why you've come to the High Court?
Now,
with order by a village darbar.
Village darbar, my lord. And lordship, the other impugned order, lordship, can you see? Page number 55. We are agree with this. So earlier prohibiting to entire members, they withdraw. Now regarding three petitioners, point number 2, my lord.
Yes.
A resolution was taken to suspend Sri Forward Lingdo Maunai, Sansad Lingdo Maunai and Sansad Lingdo Maunai to hold the position as Sardar, Secretary, Headman and members of the committee of the village or localities which falls within the administration of the Maunai village until the end of this course of opposition by the Lingdo Maunai clan against the village to the chief of Himanonglau, since they are the leaders who lead.
But that's only fair. How can you be part of the village darbar if you're against the creation and the village darbar is for the creation of the villages?
No. Therefore, that is whether the creation is correct or not. That is pending for this council.
Fine, but then how can you be member of this? How can you be member of both the parties? Suppose you say the village darbar is in favor of creation of the village, correct?
Yes.
Now how can you be a member of the village darbar then?
No, my lord. I'm against the creation.
You get correct, and then you want to be a member of the village darbar that's supporting the creation.
No.
Then, if you say that, to suspend so and so, so that's get 3 members of community village or localities before the Maunai village. Right?
As of now, my lord. As of now, my lord, village creation process is going on. And now to stop me, from raising.
Even then, this is just addressed to this EM, correct?
And addressed to others issues related.
So
now,
why before the school? Why didn't you go to the council?
My lord, this is the order passed by the authorities under the 6th schedule, my lord, village authorities. Lordship jurisdiction is extended to this even the.
Yeah, but then this discretionary
action of the. Otherwise, my lord, is the amount of expelling these people, outcasting these 3 persons.
It's not a question of outcasting. It's a question of convenience. The thing, if I understand correctly, I may be wrong, but the thing is that now you and your clan are against the creation of this new village, correct?
Yes.
The village Maunai, they want this new village to be created.
Yes.
Now they say that since this matter is still under dispute, and where you oppose the creation of the village, so you should not hold any office within Maunai village.
That's parent village.
Yes. Which is correct. Why not?
My lord,
I think the headman will have the power to say, okay, fine, you're against me. At least you relax. Let us dispute over.
With due respect, I'm still the villagers of the Maunai village.
You are, of course. You can be a villager, but can you hold office? Because they have to take decisions where they have to support, and you are out there in the middle opposing. How did it work?
My lord, my right to participate in the leadership of the village level With due
Are you
respect, my
elected
lord,
by them,
it's still
by
there, my
people?
lord. It's still, they cannot
Are you
take it away.
elected as secretary?
My lord.
Are you elected or you just appointed?
This is a secretary lordship.
This is a matter of to come.
Monarch village only. It is a clan's organization. No, but how my right to hold a leadership post in the village?
Where's Mr. Kinta? Mr. Kinta?
District council is not a party here.
Doesn't matter. They are authority. They are look after village authorities. I don't think we'll entertain this petition at this stage before this court.
I know this has a serious effect. It's a chilling effect to the rights of the petitioners.
No. Right of petitioners is fine. Rights comes with other things also. Right can't be unfettered. Mr. Kinta, have you seen this matter? You're a performer, or who are you?
No, he's not
or
a
you're
party.
Not party at all.
He's not a party.
Why? Then where do you say the creations before the council? Where have you said that?
My lord, there is a letter put up by the other side. We'll just take that one. Lordship, kindly turn page number 51. Page number 51. This is addressed by the Maunai village. May I read? With reference to subject cited above, the Kasemonai village is one of the village which is born out from the Maunai village. When closing the copy of the letter which was received from the secretary, such, praying for issuance of sanat to such, and we from the Maunai village already had gone its recommendation and will give our support to Sun's village since we had given its recognition as a new village, and the same would be done as soon as possible.
One thing, Mr. Why are you opposing it?
My lord, it is my land, my lord. The land that
the land will not go away. It's under village A, village B. The land still belongs to your clan.
My lord, when we go to the Act, my lord, Ilaga Act, before creation, my lord, it requires the consensus of the village.
Or a parent, and the parent village Maunai, they have given the green signal.
My lord, there is nothing. There is no such meeting called by the village authorities.
Then that matter is still on dispute. Now, the fact that the reason for you not like how seems quite sound. At that level, we're not going to see anything, but it seems quite sound. How can he be a member of, It's
no sense. My lord, with due respect, how can they debar me? They cannot debar, according to me, my lord, they cannot debar me.
Yes, we will do one thing. We'll dispose this matter of now only. The petitioners, I got to cut you. No need. Non-cloud has its own act, no? It has only the election of CM only.
Yes, with regard to creation of a village.
The only election of CM doesn't have administration rules.
Yes. With regard to creation of village, the Act, one Act is the Administration of Ilaka Act 1991.
That we are aware.
It covers.
It covers. No need to take down. As the matter in issue is limited only to the grievance that the petitioners have been barred from. Where the letter, Mr. Chanesa?
My lord, page 55. My lord.
Have been barred from have been barred from becoming members or office bearers in Onai village by resolution taken on. When was the resolution taken?
My lord, they did not reflect the resolution but the communication
taken by the village darbar in view of a pending dispute as to the creation of a new villages known as Pung Sasniang.
Kisai Monai.
Only Kisai Monai. There's no Kisai Monai. The petitioners I lost track this one.
petitions have been barred from becoming members or office bearers in Mona village by a resolution taken on
And before that,
as the matter issues need to permit agreements. Petitions have
well, isn't that the petitioner's thing? Yes.
petitions have been barred from becoming members or office bearers in Mona village by a resolution taken on by the village darbar in view of the pending disputes as the creation of a new villages known as
Without issuance of notice, the matter has been disposed of at the motion stage only. Stop. Next paragraph. It is clear from the pleadings that the grievance of the writ petitioners is against the village darbar of Monai village, which comes under the administrative control of the pro forma respondent number 4, that is the CM of Cloud. Which is the appropriate appellate authority to decide on disputes and such disputes. Next, it is further noted that even the district council, which is the regulatory body over CMships, has also not been impleaded as a party by the writ petitioners. Next paragraph. In this view, the matter, as the writ petitioners have recourse to alternate remedy for redressal of the grievances before the respondent number 4, at the first instance, the writ petition is not entertained at this stage and is accordingly disposed of. Parties at liberty to approach the respondent number 4 with the dispute in question. Sorry, Mr. Changri.
But with regard to that prohibition, the village matter is still assessed by the respondent number 4.
Yes.
With regard to Lordship, the direction is to approach, allow me to approach with regard to prohibition of this 3 gender.
Yes. With regard to the dispute regarding the prohibition of occupying, with the prohibition of becoming office bearers for Monai village. I'll correct it, miss.
Hearing, item 20.
This is a long process. This is a political appeal. After that, isn't it? Coming to. Yes.
May it please your lordship, I've just been informed that learned DSGI is not keeping well, your lordship. So if we may have this matter after 2 weeks.
Mr. Jha, ready?
My lord. It's with regards to the disability pension, my lord.
There is a new notification, I believe, regarding disability pension.
They should.
With the army?
This is Assam Rifle.
Even then, that'll have a sort of impact also.
Definitely, my lord.
You don't call it disability. What do they call it now? Impairment.
Impairment, and with regards
impairment, degree of impairment, right?
Yeah.
You have a copy of that?
No, my lord, I will get that. My lord, this is a covered case. 2 high courts has already granted of the Assam Rifle, my lord.
No, but Mr. Mozika is not available.
My lord.
Due to the unavailability of the DSGI due to illness. This is matter up to 2 weeks. Yes.
Valuable.
21.
Please, Wednesday.
May it please, Lordship.
Yes.
Lordship, here I have come against the order of, that is at page 48, Lordship, order of election.
48?
48, Lordship. May I read, Lordship?
Yes.
That is annexure number 11, Lordship.
Yes.
This is to inform to all the registered member of the Manraga under Kulupara Village Employment Council that as per the complaint submitted by the VC members by letter dated Kulupara 13 September 2022, the selection of new women member of your VC will be held on 28 October 2022 at IB near Police Station Mahendraganj from so-and-so. Candidates will have to submit the nomination paper in the office of the undersigned on or before so-and-so during the office hours. Necessary forms for nomination may be collected from the block development office. On the date of selection, all the registered members of the Manraga will have to bring their individuals job card holders. There will be one vote for each households. Against the order I have come, Lordship.
Why?
Lordship, prior to that, Lordship, what happened, that election was held in the year 2020, but results were not declared, Lordship. Then, Lordship, I come to the court, Lordship. Then when the matter was pending, Lordship, then results were declared and found that I have won the election, Lordship. That is at pace, Lordship. That is at page 32, Lordship. Page 32.
Order.
Yes, Lordship. This is the declaration. The result of the election for the post of President and Secretary of so-and-so was kept pending since December 2020, shall be declared on 2nd November 2021 at so-and-so to so-and-so. Next page, Lordship, the result, Lordship. Next 32, Lordship. This is for the Secretary, Lordship. There are 181 votes polled, and out of 181, the petitioner got 103, Lordship. Next is the President, Lordship. 179 vote poll for President, and out
how
of
can, but the secretary is reserved for female, correct?
Yes, Lordship.
And how come this other fellow, Shri Rimu Sheikh, how come the...
Because, Lordship, that time in 2020, Lordship, that the notification came in 2020, I think. After the election was held. Prior to that, notification was not there, Lordship.
Right.
Then, Lordship, then social agreement was executed, Lordship.
And the announced President, Saddam Hussein?
Yes, Lordship. The term of the, in the agreement, Lordship, is specifically mentioned the term is 3 years, Lordship. When the rules also says the term is 3 years, Lordship. Now,
for you, the election was on 21, declared results.
Yes, Lordship.
So, you see, you should finish off in 24.
24.
So, what happened?
Now, Lordship, the person who lost the election, Lordship, they lost the complaint, Lordship. Very few persons were the signatories in the complaint. That is in the input letter specifically mentioned. And what is the content of the complaint, Lordship? The type copy is at, Lordship, 46, Lordship. I am reading the 43, Lordship. The handwritten copy, Lordship.
46 type copy.
Yes, Lordship.
How many complainants were there?
This is very few, Lordship.
45, you mean, yes.
Not even 45, Lordship.
No, this is page 45.
Yes, Lordship. May I read, Lordship?
Yes.
The content number 1, Lordship. The VC Secretary of Kulupura VC running the VC in a dictatorship way. That the VC Secretary is not interested to develop the village, but her own property. That is why she preferred to work for personal purposes.
No, that's her own property, but for own profit.
Own profit, whatever may be, Lordship. That she behaves of the VC Secretary is so harsh towards the job card holders, that we the job card holders request your kind honor to kindly change the present VAC Secretary and save the job card holders from her dictatorship. That the VAC Secretary never conduct any meeting of the village for the development of the VAC. That the job card holder is not satisfied at all about the serious of the VAC Secretary. That as per the own will, she never enroll some job card holders on the master roll. This is the allegation, Lordship.
So you're behaving like a dictator.
No, Lordship, because this is the few person, those who lost the election, and time and again they are, it is not that we have received any, we have executed any work order. One work order is issued, that also they have lost the complaint, and after that the work order also kept in pending, Lordship. We have not executed any work order, Lordship. My Lord, kindly see the history. Election held 20, they lost complaint, then I have to come to the court. Then because during the pendency of the writ petition, they have declared the result. And after declaration of the result, time and again they are lodging complaint.
Have you been removed now?
Lordship?
Have you been removed?
No, Lordship.
Then why have you come before the court?
I have come because there is no such order saying that I have been removed. Only they have issued a letter saying that election will be held, Lordship. That is the infant. 48, Lordship. That letter I have challenged, Lordship. There is no such order saying that you have been removed, Lordship. The complaint which I have just now read, Lordship, that is
last year. What happened then? Since then till now, the stay order.
Yes, there is a stay order. Yes, stay order, Lordship. The video issued that. But although there is an stay order, Lordship, but they are not allowing me to function, Lordship.
But then you said only few job card holders. How can they not allow you to function?
The video is not giving, Lordship. Video is not giving. Again, they are supposed to issue on work order, Lordship. Again, day before yesterday.
That so I think is that videos on the side of those few job card holders.
That is, Lordship. I don't want to make any comment, Lordship. I don't want to make any comment. Again, they, I think 29th of this month, they last month, they lost a complaint saying that no order should be given to the secretary until the matter is decided by this honorable court.
That's it.
That's it.
Yes, Mr. Kharmi.
This complaint, Lordship, lodged by the job card holders, Lordship, it was forwarded to the Ombudsman.
How many people?
Here there are.
How many people signed the complaint?
29, I think. 28,
Yes.
29.
Yes, there are two complaints, Lordship. The one pointed out by Mr. Sheikh, Lordship, it's a second
But only
complaint.
when a complaint was filed, was she called for explanation?
Yes, Lordship.
She gave explanation?
She gave the explanation.
You're not satisfied with the
It was
explanation?
not satisfactory.
Where is that? Where is that? Where have you said that? Where's the explanation? You've annexed it here, Mr. Sheikh?
Yes, Lordship. That is.
And the first complaint, Lordship, it was forwarded to the Ombudsman. And the Ombudsman has given the award. It's enclosed in my affidavit.
We'll look at it. Let's see the explanation first. Where was the show cause issued to you?
In my affidavit, page 43.
So, Mr. Sheikh, how sitting here we can discern whether you're behaving like a dictator or you're a benevolent person? How will we know?
That's true, Lordship.
The video will know at the ground level.
Now there is a procedure, Lordship. Lordship, suppose if there is a complaint, what is the whether they can remove me? But there is no such order of removal.
They will not remove you.
Yes, Lordship. I have
directly removing you.
Yes, Lordship. I have left only for few months, Lordship.
In my affidavit, paragraph 8, I have mentioned, Lordship, regarding that explanation. Paragraph 8 of my affidavit.
What inquiry is conducted then by you?
Ombudsman, Lordship, it's at page 21 of my affidavit. It was forwarded to the Ombudsman as per this Ombudsman.
If my Lord permit me to clarify with regard to that Ombudsman.
One second.
As per this operational guidelines.
See page 22 D1, your statement there, and cross-examination and your statement. See, Srimati Samson Nehar, Secretary of so-and-so stated she has submitted a master role regarding improvement of community ground according to work order number so-and-so, dated so-and-so, has been obtained construction protection wall, filling
of so and so, as per the cost of 42 lakhs, only the work is immediately started. In cross-examination, secretary could not show any proceedings or meeting held prior to the officer work order. Moreover, she could not identify any public open space where the officer work can be implemented. She's going to implement in a private landed property, one job, namely Zorul Islam.
That is why, Lordship, with regard to the work order, Lordship, that work order, that is why the Ombudsman has recommended.
Very serious.
I have not executed the work.
But you said that this 42 lakh project you're going to execute in one job card holder's land.
No, Lordship. Kindly appreciate one thing. It is not the handiwork of one person, Lordship, because the social agreement, this is the body, Lordship. This is the body. Now, if there is any difficulty, Lordship, I do not have any objection, Lordship, with regard to the work.
See, one thing. If you have the confidence of the majority of villagers, then face elections.
My Lordship, only for the President, Lordship, not even 1 year, Lordship, only for the Secretary, Lordship.
Doesn't matter. It's apparent you've been examined in that Kulpara village. Is that you're going to make a ground, and there's no need for a ground of a protection wall. Were it filling nothing, even the land you could not identify.
Lordship,
and you identified the land of some private person.
Lordship, I just clarify, Lordship. So far as that is the work of the technical visited the place, Lordship. Technical assistant, the block officials, Lordship. After that, they have issued the work order. Still, if they have any complaint with regard to the work order, Lordship, BDO has every right.
There is no record of any meeting that you held.
That is why, my Lord, and Ombudsman also kindly see who has contacted the Ombudsman, Lordship. Ombudsman, Lordship. Now, what does the rule says, Lordship? There is a complaint, Lordship. My friend has in the affidavit, Lordship, says that.
See, even the pictures are taken of the inquiry 25 with the coordinates also and time. Mr. Sheikh, I'm sorry, I don't think
2-3% time and again if they lost any complaint, my Lord, always there will be rival party.
Some problem with the shareholding business here.
Yes, true, Lordship.
That's it.
My Lord, I have only 1 year, Lordship. Kindly.
Sorry, if it affects public interest, and if
then my Lord, kindly come to my petition page 12.
It's seen by a report which is seemed very detailed.
Page 12.
What have you said about this report? Have you said anything in the petition about this order of the Ombudsman?
Yes, Lordship. I have not, Lordship.
Have you challenged it?
No, Lordship.
No. Then
that is why, Lordship, kindly appreciate one thing, that they can cancel the work order, Lordship. The Ombudsman has recommended.
You're not challenging that order is against you.
No, I am.
It's an order. It's against you. That you have never had the meeting, you went and showed the land some private person to build that wall.
My Lord, kindly come to my
appeal will go before whom from Ombudsman, Mr. Kharmi, as per the procedure.
Thing against order of Ombudsman, this appeal forum must be there, Lordship. But I have to find out.
Yes, what do you want to show?
Lordship, page 12.
Otherwise, your case also is heading
before that, Lordship, if my Lord kindly come to page 9 of the counter affidavit, Lordship.
No, let's read page 12. See, that's why you can't function. Then because you are occupying the office by virtue of orders of the court, you can't function. People have lost faith in you. Who's suffering?
Again, 28% has lost the complaint, Lordship. But
that is why this court is saying, if we are so confident, you go back to the public. They elect for another 3 years.
Now, Lordship, Lordship, kindly appreciate one thing. I have won the election after facing the democratic process, Lordship.
But you didn't execute. But when you were in office, you became a dictator.
Lordship.
That's what they say.
Now, say for example, MLA and MDC, Lordship. If there is a complaint, whether because of the complaint, Lordship, the authority will conduct election, Lordship.
Yes. Now this is a matter concerning implementation of social beneficial schemes.
Lordship. That is why
so the main beneficiaries are the villagers.
True.
If suppose a functionary who's in charge of being the secretary of the village employment council has to have meetings to see the best interest of the village. If someone's not working in the village, even for 1 day they have been elected, it should be thrown out.
My Lord, if for sake, Lordship, for sake argument, Lordship, if 10% out of 100 coming and losing.
Doesn't matter. If it is found, it is not that on the basis of complaint only not hearing you, you've been booted out. This is not the case. Out here, the complaints made against you, the 2 complaints. The ombudsman took up the matter, afforded you a opportunity of hearing, took you to the site to point out the land with regard to the work order. You could not satisfy. You could not even satisfy whether you had meetings or not. So naturally, that means you've not been discharging the duties of your office. So do you deserve? Does your conscience allow you to sit in that chair when you're not serving the public? That's the only thing. If you are a new leaf, you want to change, then you contest.
My lord, what is the remedy, lordship? Suppose if any complaint is lost, lordship.
We're not going to technicalities. We'll go on substantive law. Like it's public interest.
Now,
this court is very sensitive to public interest, to pension. So the thing is that if against public interest these schemes are there, what happens? The money will be stuck. It'll go away.
My lord, so far as that ombudsman report is that they have made the recommendation saying that with regard to the work order.
No, where have you challenged that ombudsman?
I have not.
Why?
Lordship, even if that work order is withdrawn, lordship. If that withdrawn, lordship, because
that's not an argument. Yes, what do you want to show from this page 12?
Page 12, lordship. That is they have copied that powers, lordship, that they can take action as per this clause, lordship.
Clause?
B, lordship. That area employment council, lordship, down below, lordship, in the affidavit they are justifying that we can take action as per this clause, lordship. That if there are any complaint about any of the ASC members, a special meeting of the VEC or VEC sitting jointly as the case may be shall be convened by the BDO or his representative to effect any change in the VEC as may be agreed to by the Blessed Employment Council. Here says, lordship, if there is any complaint. Now, what is area AAC, lordship? Now, AAC is people comprising of the Blessed Employment Council. 7 or 8 blazes comprising constitute the area employment councils. Now, 3 members from each VEC, they are the member of the area employment council, lordship. Now, it says that if there is a complaint against any of the member of the area employment council, then the BDO can or his representative can effect any change within the members, lordship. Now they have quoted this paragraph in the affidavit saying that we have the power, we have taken action as per the provision of this law, lordship. Now the social agreement, lordship, specifically mentioned the term of the so-and-so is 3 years, lordship. Now they are saying that we can take action as per the provision of this law before the expiry of the period of 3 years, lordship. Now this provision talking about that area employment council, not the VEC, lordship. VEC is a, lordship.
Okay.
that they have mentioned in para 9 of their affidavit, lordship.
Where is your complaint against VEC member?
Pardon, lordship?
What about complaints of VEC member? Where is it? There's no provision for complaint.
No, lordship.
Then how can there be no provision?
There is a provision. There is a provision for complaint. That is, lordship. Page 19, lordship.
Yes.
Page 19, lordship. Para rule 26, lordship.
Where the ombudsman? Where is he coming?
There is no in the rules talking about ombudsman. Maybe in the early.
It's a different.
In the parent rule. No such, lordship.
At page 4, I have mentioned, lordship, my affidavit.
This is the rule, parent rules, lordship.
Page 4 of my affidavit.
And under what provision they have constituted the ombudsman? That is, lordship. Rule is silent.
Page 4 of my affidavit.
Yes.
From the top after that paragraph, after receiving the complaint letter, the respondent 3 initiated the investigation instantly and asked the allegation for under para.
Where's the operational guidelines? You have a copy?
This copy I don't have.
You have quoted it also?
Yes, I don't have it.
Bring it. Yes. Sorry, Mr. Sheikh.
My lord, so far as ombudsman is different and that rules.
Doesn't matter. It's public interest, public money. We'll dispose it off. You bring this is matter day after tomorrow. Mr. Harmi to bring the optional guidelines 2023. No, yeah?
Yes, 2013, I think.
2013.
2013 for
MNGRES schemes. Yes.
Can let it
you
be
look for that also.
Monday, Lordship. Monday or Tuesday.
Okay, Monday.
Obliged, Lordship.
Hello,
Should have said that you didn't have it with you. Well, you wasted a lot of time just hearing it. Anyway.
22. 22.
Yes, DHI is not well.
Yes, Your Lordship.
When?
Your Lordship.
1 week.
2 weeks, Your Lordship.
After 1 week, yes. He's overburdened, I think,
Obliged, Your Lordship.
due to the illness of the DHI. Yes.
28.
Yes, Mr. Nan.
This is my lord, this is a case which has been filed, my lord. The relatives of the mother and relatives of the petitioner have donated a vast area of land for the purpose of construction.
Relatives of the petitioner.
Petitioner, mother and the other relatives. Donated, gifted a land for the purpose of construction of the office of the
Agriculture,
Soil and Water Conservation Department, and accordingly it was in the year 1984. In the year 1981, that land was donated.
81.
81. And accordingly, that land was donated without any cost, and it was handed over freely.
What is the size of the land?
Size 0.47 hectare or something.
47 hectares?
Yes. Point 47 hectare.
147 hectares?
Point
0.47.
0.47.
Why do you want an acre? 0.47 hectare will be
it's
1 acre.
Almost 50,000, more than 50,000 square feet.
No, 2.5 acres make 1 hectare, correct?
Yes. So it's in the square meter around 4,700 square meter.
How much?
4,700 square meter.
4,700. Under an acre, yes. Okay, yes.
And, square feet around 50,590 square feet.
Okay, what happened?
Thereafter, my lord, in the year 2021, and gift deed was registered, my lord. Page 22. Between the Soil and Water Conservation Department and the relatives, mother and the other relatives of the petitioner, whereby in page 25, my lord, terms number 5.
Yes.
Where it has been specifically agreed that the donee, second party, as a token gesture towards this noble cause of donation of the land by the first party is considered direct appointment of a family member of the donor as per government policy quoted by it. This is dated 17/11/2014. In 17/12/2014 office memorandum in page 35, Miller, clause 7.
35.
Page 35, clause 7, where it has been adhered a provision stating that appointment to one family member of landowner donating land for government purposes.
Page 37?
Yes. Page 35, Miller, of late petition.
Oh, yes, okay. Where is that? 7.
Okay. Where it is stated, my lord, in case where private landowners have donated land free of cost for government purposes, the land proposed to be donated should be legally handed over through a registered gift to enable the government to provide appointment to an eligible member of the family or families of the landowners. The Deputy Commissioner is concerned of the concerned district will identify the post in consultation with the district head of the concerned department to which the land is being donated. Appointment under this provision will be outside the purview of the DSC. Now, in view of this gift deed, terms of the gift deed, my lord, the petitioner was appointed, given appointment, page number 36. In the post of Plantation Mali.
Okay.
And immediately after that,
page 36 in 2022 only.
Annexure 4, Annexure 5.
Yes.
It's dated 10 June 22.
Yes.
Thereafter, my lord, another letter was issued on 17 June 2022 stating that the is Annexure 7, page 38, my lord. It came from the Undersecretary to the Government of Meghalaya to the Director Soil and Water Conservation Meghalaya, whereby it is stated, I may be allowed to read. With reference to the subject and letter cited above, I am directed to say that the government regrets its inability to agree to the proposal for appointment to the grade 4 post in respect of Srimati Janailan Dengnang, daughter of the owner of the land, who donated a plot of land in Parmathao, West Khasi district for the purpose of construction and development of soil water consumption. Now, by this order, my lord, the petitioner's appointment was thereafter cancelled, my lord, by Annexure 8, page 39, in view of this letter.
Now, only one thing, it says 81, the last donated, first appointment was done in 22. Is that correct?
Yes.
So 81 land donated 1981.
81.
And no one's appointed since then.
No one appointed. No one has given. No one was not eligible also, my lord. No one approved. But when eligibility came, it was approved. And before that, gift deed was registered.
No, of course. So that's, no, just asking. So after 81, that means after how many years? 40 years?
Yes, my lord. No one
the policy came in much later.
Whatever it is, I know, I'm saying that in 81 when they donated, as per the agreement, there is agreement, and then if there's no policy, then we are bound by the recitals of that agreement.
And there was no indication that they would be appointed, or anybody in the family would be appointed.
No, it's there in that agreement itself.
The 81 agreement, my lord. So
agreement.
Without any demands. That is a part, one of the conditions of this agreement.
Is there. The
Page 18 is the 81 agreement.
Yes.
81 agreement is it was in Khasimela, page 18 in the translated copy.
The original agreement is in vernacular.
Okay, but then the thing is not registered, isn't it?
It was not required, my lords.
That second agreement.
1981.
That time registration was not applicable.
What a compulsory, mean.
But this particular document was registered with the annexed in the deed of gift deed when gift deed was registered.
So how can you rescind this agreement which is registered now in this is the 21. Latest one in not 81 in
21
2022 and 2021. How?
We're not
That's-
rescinding it. What we are
You know,
saying.
you see that the clause 5 is there in your
I
agreement.
understand, my lords. That was under a misconception because
Then-
the 81 agreement was a clear case of transfer. And can you see who had transferred the property? Hai Singh Dakhar. That's the mother. So the title stood transferred. There was no occasion to execute a fresh agreement in 21. Once the title stood transferred, it was absolute. It was a case of an absolute transfer.
Whatever it is, you can't have technicalities. The people are part of the land.
No, I understand.
If you have ongoing policy, why can't they consider
No,
under
that's-
policy?
What I'm trying to explain the timeline. 81, when the property was transferred by way of a gift, there was no condition.
Right.
The policy was introduced in 2014. They possibly learnt of this policy, and as such, they approached the department. And which is why the department initiated the exercise of registering a new agreement.
Then why did you?
This was under a clear misconception, Lord. Clear misconception.
Who will pay for that?
Lordship?
Who will pay for that?
Lords, kindly see. The property, there's a point of law involved. If the property has already changed hands and the title has been transferred in 81, there was no need, there was no occasion to retransfer the property by way of a registered agreement. This is a case of misconception. And moreover, this policy is prospective in nature, only with regard to transfers which took place post 2014.
Correct.
So the only question
What
is,
do you
did
do
the
with
transfer
agreement?
take place
Has the
after
agreement
2014?
Has it been recalled? Has the deed of cancellation been filed for this? No.
No, we haven't.
Then
we'll take steps for it because what we are saying is that the property has already exchanged hands.
You file for a special performance of this.
I was just coming to that. If at all, they would have to take steps for a civil court.
My lord, this is finished also. That after the notification came in the memorandum came 2014, my lord. After that, the agreement, deed of agreement was registered, and that time there was an agreement, put an agreement to give, and accordingly the job was given for grade 4 job, my lord. That's a great job.
Great job.
Mali.
Great job.
Great. It's a great. My lord, for me it's great. I'm jobless. I'm jobless, my lord. It's great for me. But the department cannot deny, my lord, this.
Yes. Where does it say is prospective? In this year 2014 policy decision, memorandum dated 17 November.
I did not find him.
At page 29.
Yes.
So kindly see, it says at page 35, clause 7.
Yes.
So kindly see, the land proposed to be donated. It is prospective in nature. And then it contemplates that the post is going to be identified by the district head in consultation with the deputy commissioner.
So the request went in 17 June 2022.
And also kindly see the recitals of this agreement of 21. They're talking about alienating this property, presupposing that they do have title over this property. They are also under the misconception that they have title over this property.
Who?
Kindly see the agreement of 21, which is at page 22. The agreement dated 27/4/2021. Now here Lordships will see the donors. There are 7 donors. Now kindly see page 24.
See, deed agreement is the renewal of previous agreement.
Yes, sir.
How can there be a renewal once there is a transfer?
The transfer is just by a slip of paper.
But ultimately, the Registration Act did not apply. So section 17 was not applicable to that transfer. We've also enclosed a copy of the notification, whereby it was made applicable in 1989.
Physically handed over, physically is transferred.
So they did not dispute the fact that it was already handed over in 81.
Yes, we have to make an exception then. What is in the affidavit?
Kindly see page 3, para 9.
Where is the new agreement that it is entered into?
Kindly see para.
We have justified your own actions. We have justified it instead of just placing the onus on the petitioner.
I'll just come to that. Number one, let's kindly see page 9, para 9.
Okay,
We've indicated that it was executed in 1981 prior to the Registration Act being made effective in the state of Meghalaya. Then kindly see page 5, para 14. So we've indicated the question of executing a fresh gift deed to hand over the said land to the government did not arise as absolute possession of the land had already been transferred to the government. And that this gift deed was in fact void ab initio.
But where's the culpability of your own officers?
That we've not really addressed. Then? If Lordships allow us to file an additional affidavit.
No.
This was a clear case of misconception, my lords. They were under a mistaken belief that the agreement could have been done. But anyway, my lords, it's ultimately a legal question. Lordships will have to just examine whether the property, the title of the property stood in the names of the donors. It did not.
Yes.
My lord, at that point of time it was not equal to registered, but when it was registered, my lord, as a gift deed, my lord, totally clear as they cannot deny that the land has been donated, my lord. It was declared without cost and it was handed over freely, my lord. And now it is running for years, for decades, my lord, that office also. And thereafter,
is any of the original donors alive?
The donor from 81? I don't think so. She's not alive. High Singh Dakhar.
Who High Singh Dakhar?
That I have to clear, my lord. No, she's.
And what was the relationship of the petitioner to the original donor?
I mean, grandmother. Grandmother, my lord.
Now, who's Ben Singh Dengan? I mean, in this page 22.
No, my lords, we've referred to Janailin Dakhar, who's a petitioner, as a daughter of late High Singh Dakhar. This is available in our letter dated 8th June, which is at page 38.
Yes, daughter, my lord.
But she's not one of the donors in the 2021 deed.
He's not one of the donors, correct?
She's not one of the donors.
Maybe she's the only one qualified.
Lordship?
Maybe she's the only one qualified. Saat kita pergi soalan. Tentang cuba last. What about other cases? Are you ready, Mr. Day? Yes, with the Swara matters, you're all ready? Yes. Yes, take down. The petitioner. Is
my lord, I'm sorry to interrupt. My lord, this original the donor is the father of the petitioner, and the
that's what he said, father, right?
And the executant in the agreement, my lord, mother of the petitioner.
that the predecessors in interest of the writ petitioner, namely one who Heinz Singh. Before you start, the brief facts of the case are that the brief facts of the case are that the predecessor in interest of the petitioner, namely one who Heinz Singh Dakhar, in the year on 19/11/1981 had donated a piece of land measuring 0.47 hectare to the Department of Soil Conservation Nongstoin Division for construction of office quarters. Stop. Stop. It appears that thereafter on 27th, this is which month? 27/1. April. Page 22.
Yes, my lord. Yes, April, my lord.
The way of writing is
Yes, that day after.
April 2021. A fresh deed was executed between the mother of the petitioner, amongst others, and the state respondents, indicating therein the renewal of the previous agreement made on 19/11/1981. Stop. In the said agreement, at clause 5, it had been provided that the Donny, D-O-N-E-E stroke second party respondent herein, was to consider direct appointment of a family member of the donor as per government policy which was notified on 17/11/2014. Stop. Pursuant to this fresh agreement, the respondents, which respondent number 2, respondent number 3, on consideration thereof, wide office order number 27 dated 10/6/2022 appointed the petitioner.
So that will be the respondent number 4, the divisional soil.
Respondent number 4. Right, so. appointed writ petitioner who was the nominee of the landowners against a vacant post of plantation Mali. Stop. However, by a communication dated 8/6/2022, the said appointment or the proposal so that it's a proposal that she was appointed.
Because if Lordship see the
the order is appointed and then you say propose for.
In 10th June, the divisional officer indicates that it is a case of an appointment, and
Yeah,
thereafter
then-
send the file for consideration or for approval to the Undersecretary. Because if your Lordship sees the agreement of 27/4, which Lordship was referring to, clause 5, it talks about consideration.
Nisha?
The agreement, which is at page
Yeah, okay,
22.
fine.
So clause 5 talks about consideration.
The said appointment was rescinded by the RASCINDED by the respondent number not 4. It was Undersecretary Soil Conservation.
Number 2.
By number 2. On the premise that the land was donated in the year 1981 prior to the effective date of the notification dated 17/11/2014. Stop. Being aggrieved thereby, the writ petitioners before this court seeking directions for this court. Stop again. Next paragraph. It has been contended by Mr. H.R. Nath, the Red Counsel for the petitioner, that the fact that a valuable piece of land has been donated to the state respondents for the use is not disputed, and as such, consequently, and in all fairness, it was incumbent upon the respondents upon entering into the fresh agreement to honor the same, which, though initiated, has been recalled by the impugned order. Stop. Therefore, praise that a proper directions be issued to direct the respondents to afford appointment to the writ petitioner as proposed. Stop. Next paragraph. Mr. S.N., learned senior cum advocate, on behalf of the state respondents, has categorically submitted that in the initial agreement, though unregistered, as the Registration Act had not been made applicable to these areas, it has been stated that no demand will be made by the donors. Stop. He has further submitted that from the year 1981 itself, the land in question had stood transferred to the state respondents, and as such, the fresh agreement entered into on what's the date? April 2021.
27th April 2021.
27 April is of no significance and, in fact, a nullity in the eye of law. Stop. He therefore contends that as a policy in question, as a policy came into being in 2014, and the land having been donated as far back as 1981, no right has accrued to the writ petitioner to demand for any kind of employment in lieu of the donation that had been made. Stop. He lastly submits that there being no merit, therefore, in the petition, the same deserves no consideration, and if at all, the writ petitioner may seek remedy under private law before the civil courts. So, next paragraph. Let's heard counsels for the parties considered the submissions and also have heard another word, please. Stop. This court has considered the submissions and also examined the materials on record. Stop. From the materials and as submitted, the factum of donation of a piece of land to the respondents is undisputed, as also the fact that a fresh deed of agreement had also been executed between the successors in interest of the original donor and the state respondents, wherein a clause, namely clause 5, had been inserted. Stop. For the sake of convenience, the said clause is reproduced here and below. Stop. It is clear that pursuant to the said fresh agreement, and consequent to the stipulation, consequent to the condition as contained in clause 5 above, the state respondents had considered the writ petitioner for appointment in lieu of the land donated to the government. And in this exercise, the office order dated 10 June 2022 was issued by the respondent number 4. Stop. Next paragraph. From the sequence of events, no doubt, though the land had been donated as far back as in 1981, wherein the stated policy referred to state policy dated 17/11/2014. No, sorry.
From
No
the
doubt.
sequence of events,
Comma.
no doubt though the land had been donated as far back as in the year 1981, wherein the stated policy dated 17/11/2014
was yet to come into force. The state respondents had acted upon the same. In considering and affording appointment to the writ petitioner. Stop. Though attempts have been made by the learned senior government advocate to demonstrate before the court that the agreement was a non-starter and that no reliance could be placed on the same to assert any right, comma, the culpability of the state respondents, however, has not been addressed or explained in any satisfactory manner before this court. Stop. In the considered view of this court, the actions of the state respondents
The attempt has been made by the learned CNGA to demonstrate before the court that the agreement was a
starter
and that no reliance
could be placed on the same.
On the same to assert any right, comma, the culpability of the state respondents, however, has not been addressed or explained in any satisfactory manner before this court.
Before this court, stop.
In the considered view of this court, the action of
No, I'm just stop before that. The agreement, it is noted, has been duly registered and signed by the competent authority acknowledging the gift, and as per the policy, here the said donation had been made has been made, consideration was to be given for appointment of a family member. So I'm not sure sorry, just come again.
the agreement, it is noted, has been registered.
Duly registered. Yes, and signed by the authority. And yes.
By the competent authority.
But
as per the policy, if the said
And as per the policy, if the said donation had been made pursuant to the same, the writ petitioner would naturally have acquired a right for consideration of employment. Stop. Next paragraph. Though the situation as it pertains would not render a clear right to the writ petitioner to a claim for employment, comma. However, in the totality of the circumstances surrounding the instant case and the fact that it is now a policy that state respondents consider a family member for appointment on such donations being made, it is hereby directed as an exception that the state respondents revisit the decision of withdrawal of approval for appointment of the writ petitioner as Plantation Mali and to pass effective orders thereon. Stop. Next paragraph. It is expected that the entire exercise shall be completed in a period of 6 weeks from the date a copy of the order is presented before the concerned respondents. Stop. Last line. It is further made clear that this case will not serve as a precedent for any other case, but the order passed here and above, as noted earlier, is consideration of the peculiar facts and circumstances surrounding the same. With the above noted directions, the petition circumstances pose are very peculiar. It's your culpability also is there.
I understand.
Yes.
I do this.
That's the best we can do, Mr. Nar. Just hope we recall it. Yes. Yes. Contempt first or?
No, first the writ, my lord, then contempt will go.
My
lord, 352. My lord, here, as per the last order of this honourable court,
yes,
the senior counsel for the KGDC has submitted that they are ready to issue the license.
Where's the proposal? He said you give a proposal, correct?
Yes.
Where's the proposal? Mr. Kanta, where's the proposal?
No, I have suggested before this honourable court, your lordship, that in the event the writ petitioners approach the authorities of KHADC, we will examine their case by case, because just lump sumly we cannot take a call. We'll examine each and every case.
Is there a word as lump sumly?
The other day there was a suggestion that the entirety of the writ petitioners and be considered.
Yes.
I have a suggestion, your lordship.
Yes.
That the writ petitioner can be directed to approach the authorities of the district council, and we will take a call accordingly, because they have never approached us in the first place, your lordship.
No, that is not a correct position. We have approached. Then they have asked us to get the go to the CM and then get the NOC from the CM.
Yes.
Now, my learned senior has pointed out that CM has no authority to issue the NOC.
Yes, we no.
So
See,
if that is the
court only
case,
express one thing. Now, whatever is be done, Mr. Day, is to be done as per
in accordance with the Act.
Yes.
Now, the confusion that arose was because the meetings the traders had with the Deputy
Yes.
Commissioner and our representative said that go to this aim.
Yes.
So now she's fairly submitted that fine. Let her wash the hands of this matter. Whose local authority there immediately on top of you, he is the one to issue the NOC. And then as per the Act, then it goes to the District Council. Then the proposal is put up, then it's according to them that they will decide.
If that is the case, that if we need to approach the district council, we are ready to approach to the district council. Only a time frame may be given.
Yes, we'll
to the
give a time
district
frame and I'll write down the order in accordance with, I'll just lay it down in accordance with the Act,
With
as
the
the
Act.
provisions has provided.
Yes.
That is all.
We'll approach.
Regulation of 1954, Your Lordship.
Yes, 54. Yes. Because we cannot go beyond the Act. Even the orders of the Resident Commission and even this court also was, was swayed by the early proceedings.
Yes, yes.
And so because of that, that those orders had come that get the NOC and go for the CM. And CM, so it's difficult for them to ascertain unless they're there. And we cannot go beyond the law. Statutory law. So we'll pass orders, whatever the contempt. We'll dispose all of them also.
In view of the order passed in the writ petition, that may be closed. But
Yes.
here, my lord, only thing that confusion will still remain. We'll go direct to the district council, or again we have to obtain an NOC.
No, first what he'll do is this. We will until the process over, you'll continue your trade. The thing is that you will go on application before the district council. Let them decide whether it is necessary for them to ask for separate NOC, something depending on individual applications. That's the only thing.
Because here,
because the thing is that there is he has submitted last time that trade license of the name of the forefathers and this and that. So all those things are there.
Yes.
Writ petition 379 and 361.
No,
They are
since
on the
Sardar
fathers
has
in the
nothing
writ
to
petition.
CM has nothing to do.
A deceased
Now
father
it is
license.
between the district council and us now.
Yes.
Now district council has suggested us to approach to the district council.
So
we
we'll
are ready
go-
to approach to the district council. My lord, here only the thing is this: the time frame may be given. And second thing, my lord, we will place our each and every individual cases.
Yes.
Let them decide. Yeah.
And you will assign one officer who will sit and examine them.
Yes.
Yes, yes.
Properly examine the legal.
And even afford a positive hearing if there's any
Yes.
doubts.
Any confusion is there that they can
Yes.
clear.
Yes, Your Lordship, we'll do that.
Then we'll dispose of all the matters that way. We'll pass orders.
Yes.
If not today, by tomorrow.
My lord.
Much obliged. Good
And
day.
the form which was issued by the CM will also go because he has no authority.
We have to thank Mr. Kinta for assisting.
Yes, yes. He left.
Was obliged.
Commissioner.